Hello, Patriots. The United States Supreme Court just struck a blow against incipient racism. But liberal politicians, legacy media, and lefty pundits are screaming Jim Crow 2.0 at the top of their lungs.
I thank Chairwoman Yvette Clarke and all of the distinguished members of the Congressional Black Caucus. Today's decision by this illegitimate Supreme Court majority strikes a blow against the Voting Rights Act and is designed to undermine the ability of communities of color all across this country to elect their candidate of choice. But we're not here to step back, we're here to fight back.
Yes.
Now, when this decision came out earlier today, it's an unacceptable decision, but not an unexpected decision. Because this isn't even really the Roberts Court. It's the Trump Court.
Yes.
And what we would expect from the Trump Court is an effort to continue their scheme to suppress the vote and rig the midterm elections and beyond. Because these extremists have failed America in every possible way.
This meltdown was sadly predictable, but they're wrong. Now, I was born in 1954, the year the Supreme Court decided the Brown versus Board of Education case that held that separate schools for African American kids were inherently unequal. The court directed the states to integrate schools with all deliberate speed. My school was integrated when I was in fourth grade, nearly a decade later. Now, I've seen lots of societal changes, but the most racist legislation passed since the Brown decision was Section 2 of the Voting Rights Act in 1965. The Voting Rights Act is based on several assumptions, not the least of which is that skin pigment determines how people vote. Nothing could be more racist. The Louisiana versus Calais decision, simply put, ends the use of race to gerrymander congressional districts. Now, can we agree that discrimination based on race is wrong? Of course. Then please explain why race should be used to determine congressional districts. If race is the factor used to create a congressional district, then by definition that process is tainted by racial discrimination. In 1978, the Supreme Court, which was not dominated by conservative justices, held in the Bakke decision that quotas and programs intended to integrate graduate schools were a form of reverse racial discrimination. Fast forward to 2007, and the Supreme Court held that the use of race as a factor in student assignment in public schools was a form of unconstitutional racial discrimination. So if the use of race is discriminatory in the school setting, how then can the use of race in drawing congressional district lines not be discrimination based on race? The Supreme Court rarely delivers decisions that are instantly understood in their full significance. More often, the meaning of a ruling unfolds over time through its reasoning, its application, and its ripple effects across law and culture. What some critics are dismissing as the Calais decision may ultimately prove to be one of those moments, a turning point, not toward division, but away from incipient racism that has begun to take root under the banner of progress. The importance of this ruling lies not in partisan advantage, but in principle. Voters should not be sorted on the basis of their skin color. And let's be clear, the Constitution is a guarantee for individual rights, not a blanket guarantee for any one group. At its core, the decision reaffirms a foundational American idea that individuals are to be treated as individuals, not as interchangeable members of racial blocs. That principle, long associated with the promise of equal protection under the law, has in recent years been eroding, replaced by a framework that increasingly sorts citizens by race, even when the stated goal is fairness. What makes this trend particularly dangerous is the quiet normalization. Unlike the overt, legally sanctioned racism of the past, today's version often cloaks itself in the language of equity, representation, or historical correction. Yet the mechanism is strikingly similar. Race becomes the primary lens through which decisions are made. Whether in education, hiring, or electoral design, The assumption creeps in that outcomes must be engineered along racial lines to be legitimate. The court's decision in Calais pushes back against that assumption. Take a look at the arguments of critics of the Calais decision. They argue that the decision robs minorities of representation in Congress. That argument itself is discriminatory. It also assumes that minority candidates cannot compete with non minority candidates. Who benefited from the system just eradicated by the Calais decision? Democrats. Take a look at minority members of Congress. Fully 84% of minority members of the current Congress are Democrats. So you have Hakeem Jeffries and Chuck Schumer railing against the decision, calling it Jim Crow 2.0 or worse. Are they really upset that carve out districts for minorities are going away? How would Jeffries and Schumer react if those carve out districts were 84% Republican? They'd be touting the wisdom of the decision and declaring that the time for race as a basis for creating congressional districts has come to an end. Dr. Ben Carson hailed the decision as a major victory for colorblind law. Carson argues that the Constitution should be interpreted without regard for race. He correctly points out that the Calais decision restores the Voting Rights Act back to its original purpose, stopping intentional discrimination. Carson is right. No person of color will be denied the right to vote because of the Calais decision. No person's vote will be diluted. Each vote will count just the same as before the decision. Section 2 of the Voting Rights Act assumed that candidates of color cannot compete in an open and fair election, but the 16% of Republicans in Congress who are minorities would beg to differ. And this is exactly the point Dr. Carson is making. The old view toward minorities is that they couldn't compete. He argues that this attitude actually works to the detriment of minorities. The Calais decision signals that the court is unwilling to endorse policies that rely on racial sorting as a primary mechanism. In doing so, it draws a line the government may not treat race as defining characteristic in structuring civic life. This is not a denial of history. Conservatives who support the decision are not blind to the legacy of discrimination or the need for vigilance against it. But they reject the notion that the solution to past injustice is a new system that continues to emphasize race as a central organizing principle. It is important to note that it was a Republican president who ended slavery. Republicans ran Southern Reconstruction, but it was Democrats who enacted Jim Crow laws, and Jim Crow was struck down during a Republican administration. A system that constantly foregrounds racial identity risks entrenching divisions rather than healing them. If citizens come to believe that opportunities and representation are allocated based on group membership, trust and fairness erodes. The result is a society that is less cohesive, more suspicious, and ultimately less free. The court's ruling offers a different path. By emphasizing neutrality and individual rights, it encourages a framework in which people are not defined by race in the eyes of the law. That does not mean ignoring disparities. It means addressing them in ways that do not perpetuate racial categorization. For conservatives, this approach aligns with a broader belief in limited government and equal justice. The more power the state has to classify and sort citizens, the greater the risk of abuse, whether intentional or not. History provides ample evidence of how such power can be misused. The safest course is to constrain it, to insist that the law operate without regard to race whenever possible. The court's ruling suggests that this risk of incipient racism has become too great to ignore. For those who believe in the ideal of a colorblind society, the decision is not a retreat from civil rights, but a defense of them. So, what do you think about the Calais decision? Is it a blow against incipient racism, or is it a blow to racial equality? Please share your thoughts in the comments.